Joining us this morning is Michele Okoh. She's an assistant professor at Lewis and Clark Law School teaching criminal law and criminal procedure. She's also a former prosecutor and a defense attorney. She's not involved in the Calhoun case, but she's joining us to talk about it from a legal background. So Michele, thank you so much for joining us this morning.
Thank you for having me.
Of course. Okay, so investigators and prosecutors have released very few details about this case, including the manner of death for most of the victims. Is that common? Is that a decision by investigators, prosecutors, or both? And why would they choose to do that?
Yes, that is fairly common. And there are several reasons why that would come to bear. So for one thing, when we try cases, we don't want to try them in the court of public opinion. So evidence is very important. And strategically, from a prosecutor standpoint, you can actually very much so mess up a strong case by sharing too much information. So for example, there could be a question of how certain witnesses were aware of information. So if too much information is leaked publicly, that could undermine the credibility of your witnesses. There is also the aspect in relation to just the role that we have as attorneys in the criminal justice system. So prosecutors are held to a higher standard when it comes down to our code of professional conduct. And definitely when it comes down to communications with the media, nothing is supposed to be shared that will be prejudicial or challenge the opportunity for the defendant to have a fair trial. So that is very important from a prosecutorial standpoint. And then also for the defense as well, you want to be able to defend the individual's case. So definitely they will be looking for circumstances where there may be information that is leaked to the public that may taint the underlying prosecution, at which case that would give them more grounds to challenge the underlying case. And another part of it too, the defense also needs to be careful because they don't want to be in a circumstance where they somehow accidentally taint the jury pool. So in that circumstance, you want a jury who comes forward and knows very little as possible about the case going in. You want to be able to make sure that the prosecution upholds their burden of proving the case beyond a reasonable doubt. If information is shared publicly, that could allow a circumstance where prior to deciding the case, the jury may already have an opinion about your client. So you would want to avoid that as the defense as well. And really that issue of the jury pool actually strikes both ways. So the more publicly known the details of a case, the harder it will be to select an impartial jury.
And, you know, this case is getting so much attention because we don't typically see this many victims in it. So are there unique challenges for the prosecutors or the defense when a case has multiple victims like this?
Yes, definitely. So the complexity of the case will be very significant in deciding the overall resolution. And it takes a lot of coordination. So you have to remember that the trial process itself can be rather lengthy. And not only that, the fact that the trial process itself can be traumatizing also to the victims' families and other close connections involved with the case. So there is a certain sensitivity that you have to have in dealing with those who are impacted. But then also, as far as preparation is concerned, you also need additional time to coordinate with all of the individuals involved. So for one thing, that's going to be those who are closely connected to the victims in this case. But that will also involve coordinating with additional witnesses. So that means the potential of interacting with multiple law enforcement agencies, and they all have their own individual schedules as well. Not only that, when you're dealing with cases that are this significant and this impactful, one of the things to realize is also the well-beings of those individuals who are involved. So moving forward, definitely there has to be care as far as dealing with those who are impacted by this case. So when I was a prosecutor, for example, when I was dealing with especially complex cases and especially traumatic cases, I would have a tendency to meet with my witnesses over shorter periods of time, mainly because it could be very emotionally and mentally draining to deal with all of this in one sitting. So, yes, that will all impact the prosecution of this case. Not only that, it's not just a matter of the prosecution preparing for the case, but the defense also has to prepare for the case. So the defense also has to be able to have access to the witnesses that are involved here, and then also have enough time and opportunity to prepare a strong defense.
Yeah, so I'm assuming this is going to kind of be the answer to the next question, but this trial doesn't happen until 2027. That's a lot of time here. What is going to be happening? What's next for the prosecution and the defense until the trial?
Okay, so yes. So we'll have our first appearance, right? So that's when we're going to deal with the issue of counsel to see whether or not the defendant qualifies for the appointment of counsel based on indigency. Also, to determine, sometimes there are cases where more than one attorney will be appointed, and that could relate to the complexity of the case itself. So that is going to be determined. Issues in regards to bond will also need to be determined, but then there will also be other court dates in relation to the indictment. The grand jury will have to go ahead and decide that these can be moved forward as felonies as charged. So there's going to be that layer. But then also there's the aspect of opportunities for pleas. So that usually will be kind of more in administrative sessions where the case will be rescheduled and there will be plea offers and plea arrangements made at that time. But yes, it will take a long time and a lot of preparation before we get to the point of trial. Not only that, from a legal standpoint, we should also see multiple motions that are based on law filed in the case, and all of those are going to need their own hearings for a judge to make a decision on.
All right, we're going to be watching it every single step of the way. Michele Okoh, assistant professor at Lewis and Clark Law School, thank you so much for your expertise on this morning.
Thank you.